Hello everyone, this is Anisha Sharma and this video is on the very recent Indus Biotech Private Limited versus Kotak Indian Venture Offshores. So the Kotak Indian Ventures Offshores had some optionally convertible redeemable preference shares in the IBPL, that is Indus Biotech Private Limited Company. So, the IBPL, that is Indus Biotech Private Limited, wanted to issue some QIPO, that is Qualified Initial Public Offer. But according to the guidelines of SEBI, this was not allowed to them since already they had some outstanding convertible preference shares issued. So, in case they wanted to issue QIPO, they first needed to redeem the preference shares that was issued by them, or else they had to convert them into equity shares. And for this, Kodak company was approached by them. So the Kodak company agreed for the same. But the dispute that had arisen between the two companies was related to the calculation of the formula of this conversion. So, according to the formula of the Kodak, the amount was some 30%, and according to the formula of this IBPL, the amount was some 10% approx. So, the Kodak company approached the NCLT for the matter and filed an application under section 7 stating that the corporate debtor had some amount due to them. Simultaneously, the Kodak, the Indus Biotech Private Limited company, they approached the for the arbitration under section 8 under the Arbitration and Conciliation Act. Section 8 of Arbitration and Conciliation Act allows this application only when there is a clause in the agreement between both the companies relating to the arbitration, that in case there is any dispute, they will have an arbitration mechanism. So, in existence of any arbitration mechanism only section 8 applies. So, both the company had an arbitration clause in their agreement. So, the NCLT under section denied the application under section 7 and maintained the application under section 8. Also, along with this only, Supreme Court was approached by an SLP because the Kodak company was a Mauritius based company, and since it was an international company, this was a matter of international arbitration. So the apex court was approached for this. So the Supreme Court held that mere filing of an application under section 7 does not create a right in rem, because this application can be rejected or withdrawn or dismissed by the court, or the party themselves may compromise in the coming future. Therefore, the application under section 7 was not a right in rem. Also, the Supreme Court stated that there can be 3 cases in case of section 7. The first case was that the application under section 7 may be accepted in case the application under section 7 is accepted. Section 8 of the Arbitration and Conciliation Act cannot apply, and if that act is not applying, section 7 will apply. The second condition that was given was that application under section 7 may not be allowed or may not be accepted. In that case, it is open to the partners to form an arbitration tribunal as they require, and it was on their discretion to go to any arbitration tribunal. The third case was that when the case is yet to be admitted. Now, the NCLT is duty bound to check section 7's application and when section 7 is applicable, section 8, the application under section 8 could not have been filed. So the NCLT has already stated that it will take section 8's application and rejected section 7. So the final contentions of the NCLT was that they stated that an SLP has already been pending before the Supreme Court. They allowed section 8's application, but they did not allow application under section 7, and according to the documents that was placed before them, all the issues that has arisen were arbitrable, and so they had to approach to the arbitration tribunal. And a very important note that was given in the decision was that no party, neither the petitioner nor the respondent, raised the question on how preference share would be a financial debt. Both the parties did not contended this question. So, and this was not questioned either before the NCLT nor before the Supreme Court. So the court said that we are not commenting anything on this point. Also, finally, the Supreme Court allowed SLP under section 11 and formed an arbitration tribunal, and the Supreme Court supported the decision of the NCLT in dismissing the application under section 7, and it heard and here the matter was laid to rest. Thank you.